Good afternoon, everyone. Thank you for joining our call and text compliance in 2025 webinar. I'd like to welcome you on behalf of Quality Voice and Data and Text Better. I'm Joe Scarpelli, President of QVD. We have Stephanie Knapp, President of Text Better. And of course, we're honored to have who you all really showed up for, Michele Shuster. She's the managing partner of Mack Murray and Shuster, former state legislator and leading expert in the field of telecommunication law, bringing decades of experience in the consumer protection arena, also an extensive background in the teleservices industry, regularly representing clients in matters before federal and state regulating agencies. We have an information-packed webinar today to get you regulation ready in 2025. We're going to cover Friday's breaking news regarding the Hobbs Act and what that means for one-to-one consent, TCPA rules, federal DNC, consent requirements where they stand now, e-sign act, AI calling, 10DLC and texting, some new state laws, just a few housekeeping items. Webinar will be recorded. We'll make it available to everyone in just a couple of days, so feel free to jump in and out, leave early if you have to. We encourage you to share the recording with your colleagues, please, afterwards. We will take live questions during the webinar, so submit those in the QA box at the bottom of your screen, please. We've also received several during the registration process. We're going to try to get to all of them as time allows. If we don't get to your question, feel free to reach out to any of us afterwards. Our contact info will be at the end. And with that, let's get started, Michele.
Fantastic. And most important of all, I have known Stephanie probably since she was a teenager, and I won't share any of those stories, having been very good friends with her father, Dean Garfinkel. So it's so nice to be presenting with you today, Stephanie. Thanks for inviting me.
Yeah, thanks for joining, and likewise, thanks also for not telling everyone where the skeletons are buried. I appreciate that.
They're in Long Island. I'll leave it at that. All right, so on a much more mundane, but actually more interesting lately topic, we're going to be spending a lot of time talking about the Telephone Consumer Protection Act. And while I am an attorney, and we will be talking an awful lot about legal issues over the next hour, we are not providing legal advice during this webinar. If you would like legal advice, please reach out. I'd be happy to help you with that. All right, so as Joe alluded to, this is the breaking news right now. And of course, I can tell you when you're a lawyer, everything happens at 5 o'clock on Friday, and then you spend the rest of the weekend addressing the ramifications of that. But this was very good news that we got on Friday. And to give you a little bit of background on this, there's an association called the Insurance Marketing Coalition, that has been around, gosh, only for probably about 2 years now, but boy, have they made an impact as a result of this case. And what the Insurance Marketing Coalition did was they filed an appeal to the FCC's rulemaking that changed the definition of what kind of consent is required for regulated technology when you're making telemarketing calls. So I'm going to go into that a lot more here in a minute. But most of you on this webinar are going to know it as the FCC's one-to-one consent rules, or logically and topically related rules. And what those rules did were add some very onerous requirements for companies that were attempting to get consent to make calls using an automatic telephone dialing system, a pre-recorded message, or an artificial voice call. And the most onerous of them all was this one-to-one consent requirement, which meant that a consumer could only provide consent to one company at a time. As you can imagine, that's a difficult proposition, especially when you're working with larger companies that might have affiliates or subsidiaries that are required to get in contact with consumers too, depending upon what exactly it is they're requesting information or calls for. It obviously affected lead generators tremendously. And these rules, the FCC claims, were as a result primarily of lead generators using these marketing partner lists that were hyperlinked to consent forms. And so if you clicked on those hyperlinks, a list of dozens, hundreds, believe it or not, sometimes thousands of companies that these lead generators were purporting to get consent from the consumer to call. The FCC decided that they wouldn't allow that anymore, so they went to the extreme on the other side and required that this consent be obtained on a one-to-one basis. Well, so IMC filed an appeal, and the appeal was basically what I've highlighted here in yellow, and the other two are interesting, but this is the one that ultimately decided the case. And it was whether the FCC redefining prior express written consent exceeded its authority. And to be clear on this, the FCC only has authority to promulgate regulations under the TCPA pursuant to the guidelines that Congress gave them when they passed the original act. The FCC has the ability to then do implementation regulations. But what the court, the 11th Circuit, said in response to this appeal was that the FCC far exceeded its ability or its authority when it took these additional requirements or placed these additional requirements on consent. There's nothing that Congress put in the original statute that hinted at a consumer had to be limited to giving consent to one company at a time. And so, on that basis, the 11th Circuit overruled this rulemaking. They did it literally at the 11th hour. I think the opinion was released at like 4:45 on Friday. And as a result of this, what it means, just getting to really the meat of this is that rulemaking is no longer effective. It did not go in effect on Monday. And so we are back to the old existing since, 1992-ish, and then subsequently revised several times, but we're back to those old definitions of prior express written consent. So know that this has happened. Know that those old consent rules still do have some hurdles we need to get over. We're going to talk about those a little bit in the rest of the webinar. Just as a background, for any of you that may not be familiar with the TCPA, it is the Telephone Consumer Protection Act, and it is, as I've already alluded to, a statute that is enforced by the Federal Communication Commission. And they do have the ability to implement TCPA rules, but only within the grant of power from Congress. The penalties for this can be very steep, $500 to $1,500 per call or text. And I have a bad habit of only saying call, and that's not good when you're on a webinar with Text Better. So maybe I should just only say texts. But understand that a call is a text. So whether I'm saying call or texting, it means the same thing. They are the same type of communication that is regulated. The TCPA applies to outbound calls. They also have do not call requirements, and there are different consent requirements depending upon the method that you're using to call. So if this is a regulated technology, which is how I refer to it, because it's easier than saying pre-recorded artificial voice or an automatic telephone dialing system. And it also depends upon whether you're calling a landline or calling a cell phone. So the general rules: you have to have a party's consent to use an automatic telephone dialing system or the other type of regulated technology. What constitutes an ATDS is something that we spent a lot of time in the courts trying to get a definition from that made sense. And eventually the US Supreme Court weighed in on this. They released their opinion on April Fool's Day, and it was 2022, I think, or maybe it was 2023. I don't know, the years start to mash, but it was April Fool's Day, ironically. And for purposes of what is an ATDS now, basically you have to be using a random or a sequential number generator to either produce telephone numbers or to store telephone numbers and then call them. If you are concerned about whether an ATDS is being used for your calls or texts, which I can tell you that Text Better is not, that is something you should talk to your providers about, because if you are using an ATDS, you have to get this heightened level of consent that we'll be going a little bit more into here in a bit. So if these are marketing calls, it requires the prior express written consent.
So Michelle, just to back up real quick. So traditional uploading a list of leads and calling them predictively is now not an ATDS, correct?
It is not, but I always have to stop and say, there is a potential that you could have a system that is using code that in some way may randomly or sequentially, it is a random or a sequential number generator that may be storing those telephone numbers. I haven't seen those, but when I'm looking at systems and I'm determining whether it's an ATDS, I will always ask for the code from the platform and see if there's anything in there that is code for a random or sequential number generator. Sometimes more in Vici dials, I will tell you, we've seen those types of things where that code is in there and it's not necessary. So we ask them to remove it because what happens is if a plaintiff's attorney files a case alleging that it's an ATDS, one of the first things they'll do is ask for the code, and they'll look for that random sequential number generation code. So it is almost impossible to get out of that case early. You're going to have to bring experts in and show that it's not, producing numbers or storing numbers using that random sequential number generator.
Yeah, I haven't seen that in a while, though, like you said.
I wish I could say the same thing. There's no reason for it, Joe, which is the point that you're making. There is no reason for it. I think that, there are state rules that I'm going to point out here in a little bit that talk about using a random or sequential number generator for ordering the calls. And that can get complicated sometimes because you may want to put calls in a specific order based on area code or based on where they live. And so you have time set in the right way. And so when we get to the state level, it can be a little more complicated. Really only 2 states we'll worry about. We'll talk about that in a little bit. If you're calling for informational purposes, but you have an upsell to telemarket at the end of that, that's going to be treated as a marketing call most likely. So be aware that you can have mixed calls that could turn those into telemarketing calls. And these rules do apply equally to calls to consumers and calls to businesses if you are calling their cell phones. And we'll get into that also.
So someone did just submit a question. Are the rules different for informational calls as opposed to sales calls and including text? So can you I think you just clarified that, but if you would.
So this is the perfect next slide. So whoever teed up that question for me, thank you.
Rebecca.
I have a graphic for you.
Thank you, Rebecca.
Yeah, thank you, Rebecca. That's right. So there is a QR code down in the corner of this slide, and there will be on the next one as well. And that will take you to our website so you can download this. I actually even keep this next to the desk for me because you know what, these laws are not intuitive. And so sometimes you really do need to do a flow chart to figure out what type of questions to be asking and what kind of consent you need. And so if we go down on the left side of that chart, we're calling wireless telephone numbers. If we are using an ATDS, as we've just described, or an artificial or pre-recorded voice, and it's for telemarketing calls, we're going to need that prior express written consent that was the subject of the IMC appeal. If it's for informational purposes, you need prior express consent. And maybe we could do another webinar and just talk about all the things that could be coming down the pipeline as a result of IMC, because the definition of prior express consent could be one of those, because it's not something that is defined, but the FCC has interpreted that to mean that if a consumer provides you their telephone number and their wireless telephone number as a means of contacting them, and you're calling them within that kind of grant of permission, nothing in writing, just that they provided it to you, and you can document how they provided it to you, then that's prior express consent. So a consumer providing their telephone number would do that for these informational telephone calls. If you are calling a wireless and you're not using an ATDS or a pre-recorded or artificial voice, then you don't need any additional consent. I do stick a pin in that for a minute though, because there are do not call requirements, which are the next chart. For landlines, we're only worried about using pre-recorded messages for telemarketing purposes. And for that, you would need prior express written consent.
You brought up the form submissions, Michelle. How long do you have? So somebody submits a cell phone to a form. How long do you have to get to that prospect?
There are no timelines for that. So if a consumer has provided you their consent, and so we have consent language associated with that, then that consent is good until it is revoked. So if a consumer revoked it, that would be the only thing that would take it away. There is, though, the concept of established business relationships. And within there is an inquiry, established business relationship. And if somebody makes an inquiry to your company and you don't have consent, but they've inquired about your products or services, on the federal level, you have 3 months to call them, and then that expires. So that may be what that call was based on. So basically, if you're making a business to consumer,
Same goes for text messaging too,
Yeah.
for 3 months. Yeah.
yeah, the same goes for text messages. And so if you are making a business to consumer telemarketing call, you first ask, did they provide consent? Then you, if not, then you may have that established business relationship. And if you do, so it's within 3 months of their inquiry, you're not required to scrub. If you don't, then likely a DNC scrub is required. And if a number turns up positive, meaning it's on the national or a state do not call list, you can't place those telemarketing calls. If the call is not telemarketing, then there is no requirement to scrub against the do not call list. So when you're thinking about whether you are required to scrub against the do not call list for calls or texts, to start with, it has to be a telemarketing call, and then it has to be a call to consumers. Now, I will tell you that there has been some recent case law that has been very interesting in this area, and it involved a company that was providing services to truck drivers, and they were downloading lists of telephone numbers from a state website that required truck drivers to register. And so, for all intents and purposes, the people that were placing these telephone calls, they only wanted to call businesses, and they were only getting numbers from a place that was a registration for businesses. And so they filed still a lawsuit and said that this phone number was primarily a residential phone line. And that's how they categorize consumer calls to consumers, that you're calling a residential phone line. And so the court looked at this, and they went through the facts I just explained, and said that in this case, the gentleman who had filed the lawsuit used his phone more often for and primarily for business purposes. Therefore, it was not a business to consumer call. But the interesting thing about this is the court did consider it, and they looked at it, even though it was a B2B call, to say that it was really about the type of phone number that was called. But they also said that because it would be an individual inquiry for purposes of trying to establish a class action. And with a class action, all the consumers or all of the plaintiffs have to have basically the same claim. And there's no way that you could establish that all the people in a class had the same claim when you have to look to see how each one of them used their phones. So while there's bad news about the way the court looked at that, there is good news that it would be very difficult to certify a class action, which is when the TCPA gets very expensive for these types of calls.
Can you just clarify? I'm sorry, real quick. Clarify B2B versus B2C. There was a little note there on the previous slide.
So there are exemptions to the do not call list. I always just slide right over these. If you are selling non-durable office or cleaning supplies, they are treated as a B2C. So I think this was a way that the FTC and the FCC wanted to include small business type of things in this, that if you're trying to sell them these non-durable paper, tissues, those types of things, pens, that those, and cleaning supplies, that they could fall under the TCP.
B2C, but otherwise B2B call and email don't have the same restrictions.
That's correct. But, I just caution, it's why I tell that story, that you have to look at the type of phone that is being called and whether it's a residential telephone number. And there's no way for anybody calling to know how to do that. So it's important that if you are, if you have a business to business calling campaign, make sure that it really is a business to business calling campaign.
So which means you're taking out wireless probably.
Yeah, I think I feel very comfortable advising people about how to ensure that they have a defendable position, that this is a B2B call, and that, if they wanted to, they could scrub against the do not call list, but because it's not likely that it could ever get certified as a class, the amount of damages are only the amount of times that you've called that number times 500 to 1,500. And unless you're making a significant number of phone calls to numbers in a call cadence in a campaign, generally that number doesn't get too high, and the benefits of the telemarketing outweigh the potential liability there. All right. So again, that IMC case that you've heard so much about over the last almost week now, at the heart of it was the FCC redefining what prior express written consent is. And the issues that were associated with it, what they did had to do with that second to last bullet point of logically and topically associated, and the second bullet point, which was identifying a single seller. So for the new prior express written consent, or which was actually the old prior express written consent, this second bullet point and this fifth bullet point are no longer in that definition. So for purposes of prior express written consent, we're only worried about obtaining a written agreement. And this is an important aspect of prior express written consent, or any type of written consent at this point, because there's also a case, it's called Bradley versus Dental Plans, that came out within the last 6 months. And the court held that because you are required to obtain a written signature on this written consent agreement, you have to comply with e-sign. And e-sign requires that you provide electronic disclosure notices prior to giving the consent language that they are providing their signature for. All of that to say that you can't obtain e-sign over a voice recording. And previously, that was something that was common in the industry, that you would get the consent from the consumer while you were on the telephone, maybe potentially to send a lead generator, sending it to a different seller, or those types of things. And now I will tell you, IMC is challenging this most likely. And so they may have their name in the press again here soon, but that was a real strike to the industry, saying that you could not get consent over the telephone. When you're identifying the seller, although it doesn't need to be a single seller, it does need to be clear and conspicuous who you are providing consent to. And so, what I would say about that is, while in theory you could still get consent through a marketing partners list, I would strongly discourage it, because plaintiffs are already filing lawsuits that are saying that you cannot give the identity of the seller in a hyperlinked disclosure because it's not clear and conspicuous to the consumer that they're consenting to them. So I would still shy away from marketing partners lists, but it does mean that you can put multiple sellers on in the lead language on a form. The consumer has to provide their telephone number where they're consenting to phone calls being received. And then the consumer has to take some type of affirmative action, and that's usually the call to action button on a lead form. I would encourage people not to use deceptive titles in that call to action button. It should be obvious that they are going to receive text and telephone calls. And then the mandatory disclosures at the bottom that we've always had is that you have to disclose clearly and conspicuously that telemarketing calls are going to be made, that pre-recorded message, AI, or an ATDS could be used, and that consent is not a condition of purchase. And so that's all required language. And Stephanie, I don't know if you want to chime in here at all about campaign registry. We do have a slide for that, but you'd probably say there should be some more mandatory disclosures in there, huh?
Yeah, there's law, and then there's registration requirements at the end of the day. And what you have is reviewers who are trained to look for certain buzzwords or keywords. And based on those words, if they do or do not see them, you're going to get a rejection or approval. For example, clearly indicating stop to stop, help for help, message and data may apply, frequency varies. Those are the kinds of things that they're looking for when we think about opt-in consent.
Yeah.
For text.
No, back to the voice. Can you, on a phone call, can you get consent to send a text message then? Or that's what you're cautioning against with e-sign?
The funny thing is, we kind of had discussions at the water cooler about this for a long time. We're like, there's got to be a way to get consent over the telephone. And the only way we could figure out to do it was you are going to have somebody on the telephone. They've got to be on their cell phone, and you have to send them a text that has the written e-sign disclosures, text that to them while they're on the phone. And then they have to hit yes, or I agree, or whatever. And then because they've consented to receive the disclosures electronically, then you could record it over the phone and get their consent. But if you're going to do it this way, you're going to put the TCPA consent in the text as well. So I think, and oddly enough, I was speaking at a conference last month, and somebody came up to me and said, "Hey, I want to tell you about this new product I have." And so that's something that they are doing. So something to think about if you do need to get consent over the telephone. And there are a lot of really good reasons to do that. When we're talking about clear and conspicuous, because now that the one-to-one and logically and topically related requirements are gone, we are going to be looking at clear and conspicuous again as we're reviewing lead forms. And I won't go through all of this, but these are the types of things that you look at when you're trying to determine if something is clear and conspicuous. And the law often refers to this in TCPA as being readily apparent to the consumer that they're providing consent or that they are agreeing to something. I mentioned the e-sign act. It's really worth going over again. If you don't have a consent from the consumer to obtain their signature electronically for prior express written consent, and also for do not call consent, which also requires to be signed by the consumer, that you have to have e-sign consent on your forms. And as we're reviewing lead forms, generally what we're telling businesses to do is to order it that, by selecting submit, and then number 1, agree to provide my electronic signature in as outlined in this electronic signature document, which you will link to, and then the next bullet or number, the privacy policy terms of use, and then the TCPA consent language, and then the call to action button, including all of the disclosures that Stephanie was talking about for the campaign registry. So go back and take a look at your lead forms, make sure you're getting all of the required language, and also e-sign. I've already talked about that we need to do this before and that it can't be verbal, but just another about how important e-sign is.
Were there changes to the, was a question that was submitted. Were there e-sign changes that were also vacated as a part of this Friday?
No, they weren't.
Nothing related?
Not in the IMC appeal, no. What changed was this Bradley versus Dental Plans case, where the court said, well, 2 things changed. First, in the FCC's order that had the one-to-one and the logically and topically standards in it, they said that they were clarifying language that was in a prior order that said you could get that let me back up. In 2012, the FCC changed the prior express written consent requirements. And in that order, one of the things they said was, because they were making it more onerous, is that this shouldn't really affect businesses because they can obtain consent in a number of different ways, including over the telephone using a key press or recording the call. And so that was the standard in the industry for a very long time. When the FCC issued these new rules at the end of 2023, they clarified that what they meant in that 2012 order was that if you have to obtain e-sign, then you have to meet all of the e-sign requirements. And that was it. That's all they said, all of the e-sign requirements. And so, of course, the lawyers are all like, well, all of the e-sign requirements are very onerous because they're meant for financial documents and important agreements, not to get TCPA consent. And so we knew that that was going to be the death knell to getting consent over the telephone. So that may be what that question was alluding to, because the FCC didn't change the rules, but they reinterpret them, I would probably say, without going through a rule change process. All right, so let's talk about revocation of consent. So now we've done all of the consent, right? We have all of the disclosures that we need. We have e-sign. We're keeping records of that consent so we can prove that we have it. And now the consumer wants to revoke their consent, and they have every right to do that. And so if somebody revokes their consent, we call that an internal do not call request. Those have to be kept on an internal do not call list. All companies are required to keep an internal do not call list as part of the TCPA requirements and to have policies and procedures around that. The revocation of consent rules have changed slightly in that consumers can opt out through any reasonable means. And so anything that would tend to indicate that a consumer doesn't want to hear from you anymore, here's some of the examples on the screen, need to lead to that consumer being put on your internal do not call list. And I definitely encourage you to be very conservative around these rules, and anything that a consumer could say that you think, wow, that, the stop calling is obvious, but, I'm not interested in this offer. Is that an internal do not call request? It may not be, but it may be one that if they're not interested in the offer, it's not worth continuing to call potentially this consumer again, because if that could be interpreted as an internal do not call request, it could lead to some issues. I would also say, I always encourage people to not ever disposition a call as wrong number. It's not really an internal do not call request, but if you have let's say you're calling aged leads or older numbers that you still do have consent for, and those numbers have been reassigned and you're not scrubbing against the reassigned number database, which I would encourage you to do, then you are calling somebody whose number you did not have consent to call because you got consent from a different consumer who previously owned it. And if you disposition a call as wrong number in your platform, then you are making it very easy for a class action plaintiff's attorney to certify a class, because all they have to do is ask for your call records, and they'll pull out every number that is a wrong number to establish who the classes are. So, or who the class is. For purposes of text messages, stop, quit, and revoked, opt out, curse words. I don't know, Stephanie, you probably have a whole list of things that that would trigger an internal do not call request.
Yes, these are the big ones. And then the second part is just obviously sending a text to confirm the opt-out status. You are allowed to provide instructions in that text on how to reverse the opt-out, but providing that confirmation is equally important as acknowledging it.
Yeah, I mean, that is such a great point. Because with these revocation rules, one of the things that the FCC said was you can send, as Stephanie said, this one-time confirmatory text. And in that text, you can also ask them, did you want to be taken off of all of our lists or just our marketing lists? So you can, or maybe just this campaign list, or ask it in a way that they can answer it so that the answer is obvious. But and you could do that, and then it doesn't opt out. It doesn't lead to a universal do not call request for all campaigns. So definitely encourage those one-time confirmatory texts. I should say also, you can't have any marketing language in that text. Like, are you really sure you don't want to buy this? Would not be a good message to have in there.
Before we move on, Michelle, there's a couple questions kind of related to this and previous topics, if you're ready. If somebody asks if they're buying TCPA compliant leads and then hand dialing or hand texting the prospect, how much of this applies?
Hi. So this is one of my biggest pet peeves, I have to tell you. I'm still not sure what a TCPA compliant list is.
Well, I did air quotes. I'm not sure you could have seen them. But.
Yeah, no, I couldn't see it. It's you're off to the side here, but yeah. So let's just assume that what they mean is that the lead provided consent for for your specific company, the one who's received these TCPA compliant leads. Then you don't have to worry about any of the consent rules. So it gives you the ability to place that call. And then what we're going to touch on here at the end are just all of the other requirements that are around this. So you have disclosure requirements, you have calling time restrictions. There are state requirements. Some states require consent. Or some states require consent just to even make the telephone call. So there are companies that will scrub against the do not call list and then make calls. Well, in those states, that wouldn't be compliant because you still have to scrub against the do not call list. So there are a number of other requirements that we'll go through, but that would get you through the first hurdle if you had consent that meets any of these. But obviously, in order to be a TCPA compliant lead, you'd have to have met all of these requirements.
A real quick distinction between telemarketing and communication with existing customers.
Mhm.
I think we touched a little bit on it, but
Yeah. So, you know, if we go back to our handy dandy chart, those are the informational calls that are down here, informational
Okay.
calls that are down here. So if it's a call using regulated technology to a cell phone, then you still need that prior express consent, which is that the consumer has provided you with their telephone number.
and EBR would apply to existing business. So you have to look, there's separate timeframes and rules around that, right?
That's absolutely right. Yes. There was a federal declaratory AI declaratory ruling from the FCC that came out, and they clarified something that everybody in the industry had already taken as true, and that is the TCPA prohibits using an artificial or pre-recorded voice without having prior express consent that must be in writing. And so they clarified that AI voice is artificial voice. So I don't know that this was a big stunner for the industry. And so you have to have the proper disclosures at the front. And these disclosures that the consumer can make a do not call request through a voice or key press, or if it can be left on an answering machine, you have to provide the telephone number where they can make that. Those are all pre-recorded message requirements that we've always applied to artificial voice. So that's just, I think, reiterating what the industry had already taken as true. With AI voice or with pre-recorded messages, there are a number of states that also have pre-recorded message requirements, and some of them have these ADAD, which is automatic dialing and announcing devices, which is pre-recorded message or artificial voice messages. And they require that you register it with their Public Utilities Commission. I point that out because I think it's a rule that pretty much no one pays attention to, and the PUCO is not an agency that goes after these types of things, but I can see that becoming, you know, a UDAP issue potentially for AGs. And so if you're using this type of technology, talk to your technology provider about it. All right, we're going to switch gears here for a little bit. We're kind of going more over into the privacy world, but this applies to telephone calls, but this is it's the California Invasion of Privacy Act, or SIPA is how you'll hear people frequently refer to this. And the reason this has become such a big deal is the penalties are $5,000 per violation. That is per call. And basically, what it requires is that you have consent if you are recording, eavesdropping. We'll go into some of the other ways now with websites and those types of things. For instance, if you are recording somebody as they're providing consent, and there are there's a lot of playback software out there that does this, and there's great reasons to do it. So you can prove that you have consent, but it requires that you give these disclosures. And in California, I would just especially be careful because the multiplier for every call you make if you're recording without giving these disclosures, or if you have this pen registers or tracking or tracing on your website, all of that's a violation of the SIPA if you don't have consent. So this is one definitely worth paying attention to, and has become a huge profit bonanza for class action plaintiffs' attorneys.
Would this be the same as California's two-party recording?
So a little bit different. The wiretapping, there's a separate wiretapping statute, and most states have these as well. I think all of them do. And on the federal level, there's also a wiretapping law, and those are all prohibitions against either recording or placing these trap and trace type of devices on phone lines, or now on computer site on websites. And what's different about the wiretapping laws is most of them only require the consent of one party to that transaction or that interaction. And generally that'll be the call center agent. So when you hire your agents, you have them all sign a consent to record disclosure, and that gets you through all of the states that only have a requirement that one party to that call consent. There are, though, I think it's about 12 states, right around there, 10 to 12, that have a two-party consent requirement. So
Right.
that means both of or all of the parties on the telephone call have to consent to it being monitored or recorded. And to do that, obviously, you just put the recording at the beginning of the call. This call could be monitored or recorded for quality assurance. Good enough. That's all you need. The one thing I will tell you, though, is you would be surprised how many times I'm auditing companies and that disclosure is a pre-recorded message. We all know from this call that if I'm using a pre-recorded message, I have to have prior express written consent to do that. So I'm careful about using those pre-recorded messages because it turns your whole call into a pre-recorded call.
What about seeing a lot of this being offered AI that's tapping in, listening, transcribing the call, and then giving you tips and all that, even if the call wasn't recorded somewhere, it now was transcribed or at the time recorded by AI.
Yeah. And so, the prohibition here is against monitoring or recording, and AI is definitely monitoring. And so any type of use of AI interaction or even chatting, or like I said, the track and traces on websites, all of those types of things implicate these wiretapping laws. So
There was a
really
question related to SIPA. Are calls into and out of California covered under that? Or is it just somebody living in California? What is it?
Yeah, I mean, I guess technically they could be. We're generally worried about calling into California, but I guess if you had employees that you were monitoring, recording their telephone calls, that could become an issue as well. So generally we're worried about the calling into because we can control what's happening as we're calling out of.
Gotcha. Somebody specifically asked about Florida. Is there anything like SIPA related to Florida? I know you mentioned the 12 other states with various stuff, but anything as strict as SIPA?
Send that to me and I'll respond to them. I wish I could remember all of the federal laws and then all of these individual state laws at the pool of a thought here, but especially the wiretapping, because generally we just recommend that people provide disclosures up front as if they're all two-party states. But I will get back to you and let you know about Florida.
I've got it recorded.
So, this is really important as you are gathering analytics from people that are visiting your websites. Because for a long time, I don't think people were really thinking about SIPA or these wiretapping laws when they were developing their websites and using trap and trace pen registers. The privacy laws now are bringing cookies into this as well. And so having the proper type of disclosures is very, very important. And so, evaluate the types of tools that you are using and how you are collecting and analyzing data from the interaction that the participants are having with your website. And then make sure that you have some type of consent that is being obtained from that if you're doing that pretty actively. And so you would not, a lot of the kind of secondary type of software that you may have running on your website, you may not even realize that pen registers or traps or traces or any of those types of things are being used. And so really important that you go in and analyze websites to make sure that unintentionally you're not running afoul of these. These are some of the typical ones: session replay tools, like the consent recording web services that are out there, chat features, pixels, third-party tags. All of these things fall into that. So it's just important to know. So, as we get questions a lot, so what do we do about this, Michelle? How do we make sure that we are not unintentionally falling afoul of the law here? And, the low risk would be to get consent, so that the nothing fires until the consumer affirmatively consents to that type of tracking or tracing or recording. One would be having a cookie banner. So you're not asking for express consent. You're not having them take any type of action, but you're clearly and conspicuously disclosing that you are using technology that will do these types of recording or collecting of information. And then, the least risky but harder to accomplish is just removing all third-party not pickles. You'd be in a pickle if you didn't, but pixels or other technology that kind of falls into that. All right. 10, this is all you, Stephanie.
We'll give you a little bit of a break. So 10 DLC registration, what's it for? What does it require? Why do you need it? It specifically applies to businesses looking to text with consumers from their landline telephone numbers. What does it require? Businesses have to register with a third party. And why do you need it? Effectively, registration and deliverability really goes hand in hand. If you are not registered, your messages will be marked as spam and not be carried by mobile carriers. So that's kind of the world that we're in today. What does it require? So when you submit an application, there are various data points that are needed. Your employer EIN number must match the legal business entity name. You have to have a secure and up-to-date online presence that includes a privacy policy, opt-in compliance, as Michelle and I talked about earlier, clear opt-in procedures for customer consent, and that includes those buzzwords that I talked about earlier, making sure that in your consent language, you have your brand name, your message frequency disclosure, stop, help information. You have to state clearly that no mobile information may be shared with third parties, and that consent is not a condition of purchase. So here's the thing. There's law and then there's registration. And when done right, the turnaround time is 3 to 7 business days. But if you're self-registering or working with a provider that perhaps is unfamiliar with these registration requirements, you're looking at a 10-week turnaround I've seen that ultimately ends in rejection. So like many of you, we often hear how frustrated clients are with the ever-changing requirements. And the best thing you can do is really partner with someone who knows the registration process because it is so nuanced.
Yeah.
What is the turnaround time for 10 DLC right now?
Depending on who you partner with, so 5 to 7 business days if you know what you're doing, but if you're self-registering and you're not aware of certain nuances, it could get tied up, and I've seen 10 to 16 weeks, and even then you're looking at a rejection because the rejection reasons are often not clear either. So it is definitely a point of frustration for many businesses looking to text with their consumers.
And then there was a question, 10 DLC is obviously it's required for political text right now. Is that any talk about that in the future?
It is required.
Being relaxed, I mean, sorry.
Yeah, I mean, it is required, like all businesses looking to text with any consumer. The First Amendment issue, I think Michelle could probably speak to better than I can. But again, to get carriers to carry your traffic, you have to be registered with this third party, and there are certain requirements that they have. Michelle, what are your thoughts on that?
I mean, it's a content restriction, right? They're looking at the content of your emails and they are determining whether the content is offensive potentially. Maybe they don't like what a word is, or if the content goes beyond what the consent is for, or if the company names don't exactly line up. I mean, it is definitely a content restriction. And I know that there is an appetite out there in the industry right now to start pushing back and challenging on this. There's been some pretty prolific writers out there too that have pointed out that because you can use their branded caller ID and kind of shortcut a lot of this, that they've put all these restrictions in place so that they can charge you this other fee to make it easier to get through these restrictions that they've placed, which they are equating to racketeering. So I think this is something that will be challenged in the future. But in the meantime, I can't stress enough, I have clients that come to me and they're not coming to me about compliance. They're coming to me because they can't even get things out. They can't get texts out because they have been trying to navigate all of these rules, which do change. And, you know, it is not any place that is easily explained to companies that are trying to register their numbers what all of these rules are and how they can affect the ability to get their text out. It's problematic.
Yeah. And Michelle, to your point, I mean, there's first the registration, right? And then what happens after you get approved? The problem is you have one person or employee on your business campaign that possibly sends a curse word out, and your entire business campaign gets taken down, and now you can't send any text messages to consumers who really want them and did sign up for them.
Yeah.
And so that's a problem too, is making sure that your campaign integrity is constantly being policed and managed. And a lot of these carriers are using AI inferences to scan your messages, and there are inappropriate blocks, unfortunately, and it's very rare that the sender is notified that their campaign has been blocked or taken down.
Yeah. I wonder if they're getting consent for that.
Well, yeah, right.
That's a great question.
Because
They're getting
I
it
think,
from you. I wonder if on the return ones. So
I think in the sake of time, we're gonna have to skip over
yeah,
state
think-
by state in that.
I would just point out these EBRs timelines so that you have how long you have. Somebody asked about that, and I just
Yes,
saw a
they
question
did.
come out about reminder calls or maintenance.
Yes,
So if you don't have consent, this is what you'd be falling back on. And just know there's new laws that have passed, none that are really all that exciting. So I would encourage you though to go download the slides so you'll have that information.
Great. Well, wanted to give you guys a little bit about quality voice and data and text better. Obviously, now we're here to help you. I think it's clear how Michele can help you stay compliant, right? And we hope this is all very helpful. But quality voice and data, we're an authorized shaken telephone provider specializing in reputation, telecom reputation. So whether that be your DIDs, your SIP service, we're here to improve your answer rate. And what we ask is, give us a ring. Are your calls shaken? Are they properly at a station? And what's the number and what's the reputation, right? And to everybody, we offer a free deep dive into that for you and tell you how we can help improve your answer rate, probably save you some money in the process, and get around the analytics that are marking you as spam and stopping your calls from being answered. So ask you to reach out. Any questions? We're here to help, and we can help you take a look into that for you. Stephanie?
Yeah. First of all, thanks, Joe and Michele, for putting together and walking through some great content. There's so many moving parts, but just quickly on us, we're a landline texting provider. We specialize in 10 DLC registration. And like many of you, the biggest challenge our customers face is dealing with the ever-changing registration requirements. It's why we launched our white glove registration service. So we know how frustrating it can be. And we're happy to act as a resource. So please do not hesitate to reach out if any questions pop up after this discussion. Happy to help.
And our contact information is on the last slide, I believe, and we'll be sending out the, right? Did we get to the last slide?
Yeah, I'm sorry. Let me pull that back up. I missed that one.
That's all
Sorry.
right. So please, yeah, reach out with any questions, anything we didn't get to. We have a couple we've marked down. We'll try to get back to you all. I see another one from the same person related to Florida and SIPA, so I will also send that to Michele. I guess, why don't we use the last 5 minutes to get to every question submitted here. Quickly related to AI, we talked about obviously on the outbound. How about the inbound side? If somebody's calling you inbound, there's a lot of people using it as an initial screener.
Yeah. First of all, am I displaying your contact information? I think.
No, you're not yet.
Oh.
It's not displaying.
Okay. Yes, I just can only blame this. I was married to a tech guy for my first husband, and tech hates me. Anyway, so inbound calls. So obviously we don't have to worry about the consent for inbound calls, but everything else applies. And so, well, no, let me take that back. Disclosures are the main things you're going to be worried about for inbound calls. And then we have to think about the call recording and monitoring laws. If we're doing that, we're going to make sure we get disclosures out there and get consent in those states that require it. If you're taking payments over the phone for those inbound calls, there are some potential requirements for recording those payments, especially if they're reoccurring payments. Also, just something for people that do have companies that have automatic renewals and those types of things. Those laws just changed, and you're required to provide a ability to opt out of those at least as easily as it was to purchase them. So changes happening there and notices for automatic renewals. So, but inbound calls are much safer. The only thing I would say also about that is if you are getting call transfers, make sure you understand how those call transfers originally contacted the consumer, because those original outbound calls that lead to those inbound transfers, those outbound calls have to meet all those all of those consent requirements.
There's been a couple questions related to political organizations. The first one submitted was how does this apply to IRS 527 political organizations? Are there any restrictions?
So I probably should know that IRS code reference. I don't. But you know, if we're talking about nonprofits or charities and nonprofits, that's probably a nonprofit status that you're referencing.
I believe 527 is.
Yeah, and there are less restrictions on those types of things. But if you're making a political type of call, obviously it's not a marketing call. And so you don't have to comply with the do not call requirements. You would have to keep your internal do not call list. If you are seeking donations, there could be some registration requirements that come up on the state level. But the technology prohibitions all do apply. So you do need to get consent if you are going to use a pre-recorded voice, an artificial voice, or an ATDS. So the regulated technology does still apply.
You brought up political fundraising. Are you guys versed in the difference between, whether it's for a political organization or for not political versus nonprofit? Could somebody contact you there if they have specific questions about the differences?
Yeah. We have one of our attorneys was a former in-house counsel for a charitable organization, and so she handles all of that, which is why I don't have as much information at my fingertips on that. I usually punt those to her.
Understand. Here's a quick one. What would be your non-negotiables for a company making outbound calls? Obviously, besides the written consent and DNC, anything else?
A really good contract. So your contracts become so important if a problem is encountered. And so now is a really great time to go back and look at your agreements. If you
take a look at your master service agreements.
Yeah. And I encourage people to put arbitration clauses in their terms of service. That has stopped TCPA class action. So there's a lot of things that you can do proactively to really try to minimize your risk.
Very good. Yeah, another one about political texting. Does revocation apply to those? Because most people are saying they say stop and they're not honoring it.
Yeah.
It would though, yes, is the bottom line. I think that probably ends our time here. I really want to thank you.
This was so much fun. Thanks, guys. And Joe, you know what? I realized I met you through your father as well. I'm feeling very old today.
You did. My father has been in the industry for 38 years, and I've had, and in my last 15 years there, had quite a bit of dealings with you. And helped us out quite a bit. So,
well, thank you, guys.
You don't have any childhood memories. It's probably for the best. But thank you for your time, Michelle, Stephanie. We really appreciate this. I hope everyone enjoyed, and we'll get the recording out to you all. So, thank you very much for your participation and time today.